apologize earlier. I have bad allergies right now, so if I start coughing, Ethan's promised to like tell some jokes, so we'll cut to the chase. My name is Kumar VINNAKOTA. I'm with the Dallas law firm of Skiermont Puckett, and it's an honor to be here. And also, it's pretty exciting for me. I actually was born in India. We immigrated to the United States when I was 3. And so to be actually come back and to actually give a presentation in my home country, it's actually a pretty exciting time. When I was asked to speak at this convention, I looked at all the topics, and I was very impressed with all the technical related topics and all the speakers that were going to talk about all the developments in U.S. law, European law, Indian law. But one thing kind of stood out to me, and it's also kind of why we started up our boutique firm in Dallas, was how do you pay for all this? And more importantly, in a developing country such as India, where they're now seeing the value of intellectual property, how do you pay or defend for yourself when we know that the cost of U.S. litigation is very high? For all the U.S. practitioners that are here, it's pretty common to know the value of what an IP litigation lawsuit is. And I guess what I wanted to do here was educate the folks here of there is costs that are involved with everything that the speakers have been saying in this convention. But more importantly, how do you know how to pick the right lawyers, and how do you work with your attorneys to make that cost effective? And so one of the trends that's happening in America right now, and this is also for domestic clients, is the use of alternative fee arrangements. What we typically talk about hourly contingent fee arrangements that I think most lawyers know about, those models are kind of going to the wayside. Clients are kind of getting smarter on challenging their lawyers for certain services on whether they want to pay for them or not. And so the purpose of this talk is to basically educate everyone here about that, and have some fun hopefully with that. And so the agenda, I'm going to talk, I have a couple introduction slides. Then I'm going to jump right into the patent litigation costs in the U.S. And it's good that Ethan talked about the ITC, because some of these numbers don't include a couple things, which are ITC costs, and also what the AIA did with respect to the new inter partes review procedures. So to wake everyone up, I'm going to start off with some jokes, because I used to be a comic before I became a lawyer. The first slide, a guy comes up to Santa Claus and says, "I wish the court to uphold my patent." And Santa says, "I do toys, not miracles." And this is so people are kind of awake here too. Father's reading to his young daughter the patent regulations, and she's fast asleep, and he's going to work every time. So hopefully I woke someone up here. And I actually do appreciate everyone actually coming here on a Saturday at this late. You know, that's kind of cool. So I'm going to jump right into what U.S. practitioners probably know. This is from the American Intellectual Property Law Association study in 2011. They update this almost every year. But this is basically patent litigation costs in the United States on the district court level. And what's interesting to see here is that as your amount in controversy goes up, so if you're less than $1 million, the fees to the end of discovery, it's not even trials, it's $350,000 on average. You go through all the way through trial, it jumps up to $600,000. But as you get up to the higher range of amounts of 1 to 25 million, you can see it sort of exponentially starts growing up. I'm going to talk about that for a second. Now, what I mentioned earlier, what this does not include actually is the cost of an ITC action. Now, what Ethan said is this is accelerated, an ITC action, and anyone that's ever participated in one knows those costs go up probably even higher than this. What's also not included in this, and what there's not much data, is what the AIA did in America, which included that inter partes review, which defendants are now starting to use. And personally, it's going to be interesting to me to see what those costs will do to the actual cost of litigation, because you could also have parallel district court litigation. So, as I said, patent litigation is expensive. And the primary reason is because the high costs are reflective of the stakes involved. You know, for those that are, I started doing commercial litigation before I got into patents. And, you know, you do your breach of contract, you do your normal business torts. Those levels of damages are kind of confined. Patents, on the other hand, are completely different. Anyone can know that. These are assets of a company that can make or break another company. And so if one were sued by a company that's enforcing its patents, and that's all sole business was the widget that it was making that's being accused of infringement, it could potentially drive that company out of business. Now, with respect to foreign clients, this is kind of important. The risks of the stakes, the uncertainty, and the predictability of U.S. juries deciding complex technical issues, is kind of foreign also to international clients. But most people also know is vast majority of the cases settle before trial. But yet, if that's the case, why are the costs so high? It's because there's a lot of unpredictability of when the case will settle. Because you might have certain dispositive motions out there to basically end the case if you're a defendant, or you might have some great Markman claims as a patentee to basically prove infringement, but you never know exactly when the court might get to that. And in the meantime, you've got to still do the process of going through discovery, answering depositions, answering interrogatories, and all the normal procedures are going on. And so that's why the costs just start piling up at that time. Now I'm going to deviate a little bit and kind of get away from patents for a second and just talk about law firm pricing in general. And this is kind of important because there needs to be, the whole point of the takeaway of this is there's going to be a synergy between the patent litigation and the arrangement with the client on how to make the law firm profitable too, right? I mean, that's why we are in this business. And so I created this representative graph right here. And, kind of like intuitively, the pricing for any law firm to take on a case, whether it be patent or anything else, I think there are 4 buckets. The strategy, right? If it's a simple contract case, not much strategy. If it's a 10-patent case with 400 claims involved, you're going to have a lot of strategy. You're going to do an inter-parties review at the same time. Are you going to have to defend an ITC action? You might have thermonuclear war going on with, like, Apple, Samsung, for example. You have competition. Look, there's a lot of practitioners that can do IP law out there, okay, and IP litigation. So your pricing is going to needs to be competitive to deal with your guy next door. And also your brand. Obviously, we're in this business to make sure that our reputation as attorneys are good. So you got to make sure that your pricing is reflective of the brand that you're trying to portray to your clients. And then finally, and I kind of end this last, is the clients, but it really should be first, in my opinion. You need to understand what your clients' needs are. Some clients might want to settle early. Some clients might want to, for principal reasons, take it all the way to a jury trial in America. But you got to understand your clients' needs, and that's also going to be reflective in your pricing. So what is the profit motivation for law firms, right? Anyone that's worked in a billable hour firm knows that increasing rates over time have driven profitability. I mean, that's just a given, right? You raise your rates, you're going to get, and for the same services, you should be more profitable. And profitability is critical in attracting talent at all levels. When I was in law school, you knew who the top law firms out in the nation were, and it was based on how profitable they were. You want to make sure you have some job security. And now what's interesting is the high-quality talent attracts clients for their most important work. If I know that the leading expert in patent litigation is at X firm, I'm more inclined to go there if that issue is coming up. Brand communication. Now, the rates, as I said earlier, sort of signify about your brand, right? There's some stigma associated with, are you lower rate, higher rate, or whatever. But the point of this whole talk is that the effectiveness in creating the alternative fee arrangements, which we'll talk about how you structure those, can play a critical role in brand building. Because although you might come out under other firms, you actually are more efficient and get a better result for your client, and you can get more repeat business. And again, alternative fee arrangements are a relationship builder. Remember I said I sort of ended with clients, but I said that should be the first. This is more of, I'm going to deviate, this is more of a personal opinion more than anything. I think that law firms in general, maybe US-based law firms, have kind of forgotten that we're in the business for client service. And philosophically, the principals at my firm and I, what we really wanted to do was to make sure that client came first and that we serviced our clients' needs in whatever it took, even in the type of fee arrangements that we were trying to deal with them with. And we also believe that having these alternative fee arrangements, having a diverse case-by-case fee arrangement, could also give you a competitive advantage over the next guy who's kind of structured in a very rigid way of, this is our billable sheet, we can't deviate off of that. We at least are a little bit more flexible based on client needs. And one interesting thing is, I think this is a trend where most U.S. law firms are looking at anyway. Now, so why is that happening? And we're going to talk about why there's this proliferation of alternative fee arrangements, and we're going to take from the client's perspective. And so the first question is, what do clients want, right? Well, clients care about the relationships and the perceived value that they're getting. We all get that. They want the strong relationships that are based on understanding and satisfying their needs. And they also, this is kind of important, they perceive value differently for the type of work that is being done by the law firm, right? So if a first-year associate is drafting discovery versus a senior partner arguing a Markman briefing, I can tell you the in-house counsel is going to perceive the senior partner arguing the Markman briefing to be more valuable for the ultimate result of the case. And then clients perceive the highest value when the fee structure meets their goals, right? You don't want a client at the end of the day come back to you and say, well, I don't want to pay for that because I don't think you did a good job. That would be the worst thing for a lawyer to hear. So what you try to do at the beginning, try to temper those expectations and structure your fees accordingly. And especially in patent litigation, that's very important because the first slide I showed you showed how much the fees are going to cost. And then clients want law firms to propose AFAs, and we'll get to that in a second. And again, they must trust the AFAs the law firms propose. So in 2011, there was a Fulbright litigation trend survey of in-house counsel in the United States. And I'm going to put all these little statistics up in one and summarize them so we can move along. And what these statistics all said was, this is from a 2011 study, that AFA proliferation in the United States is trending upward. Clients, as I said when I first started this, are getting very smarter on challenging their lawyers on why are we paying for certain services when it doesn't seem cost effective, it's inefficient. So basically challenging the law firms original, we got to talk about the goals. Alternative fee arrangements, the goal is for the proper, is to align the interests with the firm and the client. If you can't figure out the theme that I'm trying to get here is law firm needs to be in line with the client. You have certain fee structures where you have misalignment, and in which case, as I said, this is philosophical on my part, that's not why I'm in this business. And what's interesting, at least in personal experience, is that clients will end up paying premiums, right, if they actually find predictability in their fee structures, especially in a patent case. If they know that certain events are going to happen, that are going to cost me a certain amount, they like that. And they actually will pay for that in the second round if you get the repeat business. Now, on the law firm side, the AFAs actually incentivize efficiency, whether you're on the defense side or the plaintiff side. And the reason why is because when you give alternative fee arrangements, the law firm is taking some risk. So to mitigate against that risk, it has to be efficient, whether it be staffing needs, whether it be the type of stuff that it can put to third parties. The way they originally have their structure has to be basically congruent with the fee structure. And again, the point of this is if you do a successful alternative fee arrangement, we think that you're going to get repeat business. And that's the success story right there. So back to what I originally said. The three basic fee arrangements that we all know about are hourly, flat, and contingent. This is when I first started off being a lawyer, we fell into one of those. And as what's really common sense here, risk shifts progressively from client to law firm as you go from the hourly to contingent, right? Hourly, there's not much risk for a law firm. They're going to get paid no matter what. But by the time you get to the contingent, the law firm is taking a lot of risk because they're putting up a lot of the front end expenses up front with no guarantee of getting any recovery on fees, depending upon if they're a plaintiff patentee. And again, but with that, the rewards grow with the risk, especially for a law firm side. And this is the key. The whole point of the alternative fee arrangement is it's to basically distribute the risk equally between the client and the law firm so the interests are actually aligned. for the ultimate result. So these are all the sorts of types of alternative fee arrangements that are out there now. Okay, so you have the flat fixed, the cap, the contingent, which we sort of talked about. The partial contingent, right? You don't have to be 100% contingent. You could have like some flat rates in there built in. Defense contingent, this is interesting. If people don't ever use that, I've actually used this one. We were actually involved in a licensing negotiation on behalf of a licensee in a renegotiation. So technically we're defense, right? The way we got paid on this case was we basically said that we get a percentage of the savings to a certain cap of the amount of the licensor demand, right? So if the licensor wanted X, we saved the company the delta of Y, we got a certain percentage of that delta. So that's what I meant by defense contingent right there. Phased holdback. Holdback is interesting, right? You have a fixed amount that you pay each month or hourly, but a certain percentage is held back by the client, and it goes to the next point of where you could either give that as a success bonus back to the law firm if you get a successful result, or you could either multiply it, or you could hold it for the next case. Now I'm going to talk about some best practices in crafting these alternative fee arrangements, especially in the patent sense. And this is for interest of time. I want to kind of sort of speed up a couple of these slides right here. But when you're working with your clients, the bottom line with the law firm is you need to understand, one, what the client business is and what the client wants, and so you can be accountable. And clients, you know, it's funny. When I start talking to a lot of clients when we're in alternative fee arrangements, I seem to have a better interaction with those type of clients than when I have like a fixed hourly rate. For whatever reason, when the law firm is engaged, the clients are equally back engaged, and you actually get a better result, in my opinion, that way. And again, the whole point of working with the clients is to make sure as the lawyer, my job, especially on a patent case, is I'm aligned with their interests. And I got a case study that I'm going to talk about here in a second that kind of shows, that demonstrates why that's important. And for the law firm processes, the bottom line is, again, when I talked about alternative fee arrangements actually increase efficiencies, there's got to be a little bit more transparency. You know, when we started our law firm, we made sure that even our first year's associates understood a little bit about law firm economics. We didn't want to keep the black box. And the reason why is because when I have a trial team, it's myself and a first year against, who knows, army of, let's say, lawyers on the other side. That first year's got to understand why we are structured that way. It's based on the fee arrangement that we've decided with the client to be the most maximum efficient and to maximize their needs. And one other thing is we try to keep metrics about this. Even if I'm doing a defense case or a plaintiff's case, I try to keep track of exactly what hours are going to what, so that at the end of the day I can basically restructure my alternative fee arrangement for the existing client for another matter or for a new client to know exactly where my efficiencies and inefficiencies were. Which I just said right there. Okay, so to set the prices, again, when a client comes to me and says, hey, I'd like you to engage you in this matter because I got sued on this patent infringement matter, how do you set the price? Especially when you're throwing out the window your typical hourly rate. Well, it takes a little bit of risk on my part. We actually have to do a very detailed case assessment plan, and we pride ourselves at doing that, of actually evaluating the patent, evaluating the technology, evaluating the industry that our client is, and more importantly, evaluating where our client's needs were. Does the client want to do an early settlement? Does the client want to go all the way to trial? And we usually cap that at a certain fixed rate and give it to our client. Say, here you go. This is what we think it will take to go all the way to trial. Now let's start working on each phase on what the costs are going to be. And at the end of the matter, what we try to do, like I said, we try to keep metrics of all this to see how close we were to our initial case management. And it's actually been a really neat and an iterative process. We're getting a little bit more efficient in judging the cases on the scope of the cases. And that's kind of all the same thing. Now I'm going to kind of blow through these slides right here, but you know, this is to be efficient in the legal, on the law firm side, you have to have sort of project management, which is kind of counterintuitive in a law firm. You never see that. As an engineer, that kind of makes sense. Anyone that's an engineer in here or technical degree, you always had project management. You know, you had your little graph that showed you where you were on scopes and time deadlines, where your deliverables were. You know, you don't usually see that in a law firm setting, but, you know, we've instituted that in our firm only because we try to keep track of these metrics because we want to make sure that we're efficient to make sure that our fee arrangements were actually commensurate to that. Knowledge management, I'm just going to blow through these slides, but bottom line is we want to make sure that we keep the knowledge base that we learned on one matter to another. This is kind of the same that we do no matter what fee arrangement you have. You don't want to reinvent the wheel. But one efficiency that we try doing, though, is when we do our staffing models, you know, we make sure that, like, I have a chemical engineering degree. You know, I worked at Exxon, yet I'm a trial lawyer now. So we try to get the staffing needs of, you're not just pigeonholed of doing one task. We want you to be able to do everything. So when we were interviewing people for our firm, we made sure that, yep, you have a technical degree? Check. Do you want to go to court? Check. You know, can you deal with clients? Check. Because what we didn't want is one person that just wanted to do brief writing but didn't want to do the rest of it, because that just builds in inefficiency at that point. We wanted everyone to be able to pitch hit on whatever task it may be. And there's also alternative ways, too, of doing that, right? I mean, you could also have non-partner track lawyers, and these are all ways of doing contract lawyers for very specific projects, in addition to just making sure that the actual employees that you have all the skill sets that you're looking for. And now this is kind of important, too. You know, one of the trends that's happening in the United States is a lot of what used to be typically high profit margin centers, you know, document review, privilege logging, it started being now outsourced, you know, to vendors here, even in India. And we believe that that's very important if, with the alternative fee arrangement, too, to be actually open to these type of arrangements. So I'm almost done here, but I'm going to tell you a quick case study where we had a patent infringement defense AFA. Okay, so we were retained to defend a client that got sued for patent infringement, and the arrangement was a flat monthly with a holdback bonus. So each month, the defendant or the client would send us a check, but a percentage of it would be held back. And that goal was, if we got a very successful result, we'd get the holdback and times a multiplier that was in our fee arrangement. Now, before we got to that point, what we did was we worked with the clients, the facts, and the case, divided the litigation into the following phases. We did an early case assessment before the answer, so to basically map out what it is exactly that they were sued for. Once we did the answer, we had a discovery phase, how much discovery we thought would be needed, or in our case, how much we had to probably deal with from the plaintiff. Claim construction, expert discovery, dispositive motions, pre-trial trial. You're basically following a scheduling order right there, right? And what we did was on the early case assessment, we said, here, this is a flat rate of X amount of dollars. You can take it, our work product, if you want to, and you can go to another law firm if you want to get a better deal. That's all we said. They paid that flat rate. We did the early case assessment. We knew we were eating that cost, right? Because they could have taken our work product and done whatever they wanted with it. But they liked it, and there was like a little intuitive thing that was going on, we thought, was we knew the case so well, why would they go to someone else and try to retrain them, right? So we got hired on the case. We did all these steps. And again, we negotiated a percent of the monthly fee as holdbacks, and we were very successful in this case, and we got the holdback by a 2 times multiplier on that case. So what was the point of all this, and what's the takeaway from this? Patent litigation is very expensive. It's very exciting to come to India because at the prior law firm I worked at, it was about 5 or 6 years ago, we were going to China, and I was having very similar discussions with the Chinese on the value of their IP and what it is that they need to do with it. Well, you always knew India was about 5 or 6 years behind that, and it's actually good to finally see India here with these conventions right now. I think the light bulb is starting to go on that the intellectual property itself is a valued asset. The key here, though, is you need to make sure that when you're dealing with law firms, to make sure that the value of the asset and the client, whether it's plaintiff or defendant, is aligned with the lawyers that you're representing who know all this technical knowledge that you're actually learning here on this, I guess, in this convention right here. So that's my presentation. If you guys have any questions, I'm more than happy to answer it. So.